30th, 2022. Welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan in the spring of 2020. Every Thursday morning at this time, Jean Lawler and I, Sarah Agameri and Natalie Armstrong are delighted to host another great webinar on a cutting-edge topic. There's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And our audiences have been so generous with their contributions in honor of our great speakers. Jean, would you please do the honors? It's one of my favorite parts of the webinar each week when we announce the running total of the amounts that our generous audiences have contributed.
It's my pleasure, Jeff, and sorry, and everyone. Today, the total of about donations of which we know, people who've told us about donations, we are at 290,000, that's 290, $225.86. So almost $300,000, and that's more than 3 million meals. That's fantastic. So thank you. So generous.
Yes, indeed. Thank you so much. And today we have another great speaker to present to you on another cutting-edge topic. Eliana Torres will be speaking to us about non-fungible tokens, current cases, and disputes. We're going to talk about recent disputes, lawsuits the NFT world has generated, and how we can get them resolved more efficiently. Eliana is a practicing intellectual property attorney, NFT collector, real estate investor, and retired fitness competitor. After being introduced to blockchain, Eliana became an avid collector of NFTs, where she witnessed many issues involving intellectual property. It was then that she decided to use her unique ability to translate complex IP issues into actionable solutions for IP creators and collectors. Eliana practices law for the federal government. In addition, she serves as special counsel with Web3 attorneys, where the mission is to empower innovation through blockchain, NFTs, DAOs, and tokenization. She's also committed to educating the Spanish-speaking community about NFTs and Web 3.0. Eliana serves as a leader at the American Bar Association, as chair of Latinas in Tech DC chapter, and she is a Discord moderator. And it seems that you can't go to a conference relating to NFTs these days without seeing Eliana Torres speaking on one of the panels, regular on the circuit and a true expert. Eliana, why don't you tell us a little bit about the food bank to which you would like people to direct contributions if they're in a position to do so, and then tell us all about NFTs. The floor is yours.
Yes, of course. So to me, the food bank that I chose was in Alexandria, Virginia, which is where I was living before. And I grew an attachment to that area and I saw the need there. So I picked that one instead of where I currently live, which I recently moved to the Chicago area. So if you hear a lot of noises, that's why. It's a little bit more hectic than it used to be back there.
Great. And the name of the food bank is?
The Alexandria, Virginia. And I will get the name for you in the chat because I don't remember the full name. It's a bit lengthy.
Yeah, that's great. Thank you so much. And now on to the topic at hand, please.
Of course. I'm going to share some slides, and I'm not sure if this will be helpful for anyone because I oftentimes like to explain what an NFT is, but I'll start from the beginning. And if this is a little bit too, if you guys want more of the complexities and kind of skip a lot of the intros, please do let me know or stop me if there's any questions along the way. So I do have a few slides about the blockchain, and we all know it's a technology that allows the computers to agree on a specific set of values, and that those go into each block, and each block get added to the chain. The chain is impermeable and it is transparent, so anyone in the public can see it. This chart here is really helpful for me to kind of understand the complexity of the blockchain and how it works in practicality. So you have a transaction, there's validators that agree upon the transaction, and that's what makes it a little bit less secure. more secure, because there is not one central authority that dictates whether that transaction is correct or valid. So there's multiple nodes or multiple computers that are agreeing upon this transaction. So that's what makes the blockchain kind of useful in different types of uses. So this is important to us as we move forward into new technologies and new future uses of blockchain, because it creates a level of trustworthiness and is just transactionless cost and a lot of time consumption that will be reduced by using of the blockchain. So I do think that we're moving in that direction, the decentralized way that we have transactions now and the ownership that people can have over their own transactions. It's valuable. And if I'm going too fast, please do stop me. I'd just like to go over a few of the key areas that kind of form the basis of non-fungible tokens. So now going into non-fungible tokens. So we have tokens and then we have non-fungible tokens. So some of them are fungible. So sort of like you have a Bitcoin. So you have one Bitcoin that translates to one Bitcoin, the same way that if I give you $1, you give me one back and I don't ask you for a specific dollar. When it comes to non-fungible tokens, it's more like artworks or something that is unique in value. And if I give you a Mona Lisa, you're not going to give me the same Mona Lisa back unless it's the original one, right? So there's uniqueness to it. The actual original one is going to remain as the only and original, and the provenance of that painting is going to remain in that specific painting that was the first and the only one. So those are the uniqueness hashes that you have in the non-fungible token. And what I mean by hashes is there's this set of numbers that go on the blockchain that make them unique, and they get recorded in the blockchain. So you have a smart contract that creates these tokens, and these tokens then through the smart contract get recorded in the blockchain. That's the easiest way to kind of understand it. And the smart contract, the best way to understand those is that they have the best analogy I've been able to find to understand it is a vending machine. So let's say you have a vending machine, you have a token that you buy a soda from, that once you put the token in, it spits out the actual soda. So the same way a smart contract has a what if value. So once you have this specific token, if you put that functionality in, it gives you a result. So if X, then Y, sort of like a vending machine. You put it, if it's a dollar that it requires, then you have the dollar and it gives you back the soda. So that's why the way smart contracts are coded, so that they create this non-fungible or fungible tokens that get them recorded on the blockchain. So non-fungible tokens kind of represent the ownership in different assets, whether those are digital or physical. So I could have a non-fungible token that it's sort of like a deed to my house, in the same way that we have a recorded deed to our house and we don't carry the house with us. The same way the non-fungible tokens is the actual token that represents something else that I have ownership interest in. Any questions so far? I will stop if there's any questions. Okay, so so this is kind of a visual image of what the token represents and what it points to. So again, it's not, you own the token, but then what it points to is what you have an interest in, and not necessarily that you own it. It dictates the pointer. It tells you usually through the smart contract what you own and how much of it you own. So I'll get into the nitty-gritty of what exactly dictates the ownership of the what's inside the actual token and what it points to. But usually, again, it's created and managed by the smart contracts. And then the creation of it's called minting. And that's just basically the execution of the code of the smart contract that gets recorded on the blockchain. So here is, will be a representation of what, if you go to any of the marketplaces, this is what you would normally see, which is the image, which is what is connected to the token itself. And these are the properties that this specific token has. So just the description is a jelly and is googly, and that goes into the smart contract. So the smart contract is the ERC-721 that you see there. And it also has a section with the metadata, which is basically, you may think of it as a descriptor of what exactly you're buying. And oftentimes that's when you have the URL or the URI. So it's basically a pointer of your ownership. So that metadata is going to point and direct to the art that you see on the left-hand side, which you see the jelly. Does that, I hope I'm not confusing anyone. I know it could get a little complex at this point.
So Eliana, we're using NFTs to refer to more than one thing. The NFT could be the artwork itself, like a crypto kitty or a Bored Ape or one of those, or it could be a symbol of ownership of something else in the same way that the county recorder records deeds. Using NFTs on the blockchain can indicate ownership of just about anything, can't it?
Absolutely. There are some car companies, and well, the real estate market is another side, but there are some car companies that are utilizing NFTs to track provenance and ownership and any modifications to cars. So for example, you purchase a car and they issue a token, non-fungible token that is connected to a specific car. So when you sell this car or you make any modifications to it, they update the metadata on that NFT so that they know what changes the car has gone through. Or if you sell it, the NFT transfer with it. So then you have the transaction, you could trace it back to the beginning. So from the car dealership to the newest owner. So yes, you could basically have an NFT tied to absolutely anything.
I can't wait to hear about the disputes that could potentially arise from that. My mind is going crazy with possibilities. I'm very curious to hear the rest of the presentation. Please continue.
Yeah, so this is the fun part, and this is where we are having a lot of issues as IP practitioners. And again, I don't consider myself an expert because I don't think there is an expert. This is just too new and too nuanced to be able to kind of dictate whether there's a right or wrong answer on any of these cases. We still don't have a lot of precedent in a lot of these. We're still waiting for a lot of answers from a lot of these cases, and there's motions to dismiss that we're waiting on just to see how the courts are going to treat NFTs in general. So the first one I'll go into will be the copyright and the artificial intelligence. And this one is not, they did not touch on NFTs. And this is just an appeal to a board. The Copyright Office issued a decision that basically you need a human author to be able to copyright an artwork. So this is particularly interesting to the NFT space because a lot of the artwork that we have is created by AI technology. So the generative art collections, a lot of them are created by putting in a set of layers into a specific blender, what they call a blender. And this blender creates multiple iterations of these layers and spits out a collection of 5,000 to 10,000 different artworks. So this one is particularly interesting to us to see how it turns out because we don't know whether we could get a copyright registration for a lot of the works that are used in NFT projects, which are usually the generative artworks. So this one in this case is just one specific artwork that was created by Dr. Thaler, who's also appealing a patent decision on the actual system that he created to create this artwork. But this one, this particular case is with the Copyright Office. It started with just a decision that was denied or rejected for lacking authorship. And the Copyright Office does not allow non-human entities to be authors. But this particular Dr. Thaler argued that he argued three main points. The first one is that we do allow under certain conditions that to have non-author or non-human entities to be granted copyright works, sort of like we have the work for hire doctrine. He also argued that there was no precedent to dictate this. And then there were a few other issues, and I'm gonna go on to the next slide to explain those. Basically, this is the entrance to paradise. The first decision that was rejected by the board, the final rejection was in February. He appealed in June, and he filed an appeal with the U.S. court in District Court in Washington, D.C. And he basically, again, he argued the protections of AI should be granted to the created works of AI that he made, because a lot of the artwork that he created was specifically using a system that he also coded himself. So that's part of his argument. He argued that there was no case law to support the decision, and that there should be a different test that should be utilized, and that is whether a machine can sometimes create something that is indistinguishable from a person, just for purposes of the copyright protection. And the last argument he made was that the work may be classified under the work for hire doctrine, the same way that we have now. So this is particularly interesting in that regard. We don't know how it's going to turn out. We do know that the UK and China have already agreed to have AI works that could be copyrighted, which kind of elevates the pressure on the US to kind of have something similar in place. So moving on, this is a few of the first copyrights and trademark cases that we have. This one was early on. This is just a pretty clear example of the issues we're seeing, where there's no actual contract between artist and founder, or the major founders just dismiss completely having any kind of sort of legal entity in place. This one is just a clear copyright case where you have Weather Report, which was one of the projects, and then the former artist sued the founders after they excluded him from the actual offer for sale. So this one is just based on the character that he initially created, and the space is very unregulated in the sense that they actually took it to Twitter before they filed a lawsuit. So it was a lot of Twitter chatter about what exactly happened, and it was very not the way that we would see a normal case go about the actual claims. So a lot of is he said, she said sort of arguments, which is interesting. But that just tells you how unregulated we have this industry right now, and how social media is kind of taking up a lot of the disputes. And please stop me again if there's any questions. I can't see the chat, so if someone wants to just quickly stop me, please do. I'll move on to the more controversial ones, Nike StockX. So we have all heard that Nike sued StockX for having been infringing the trademarks for owned by Nike. This is an interesting case in the sense that StockX might have an argument potentially to kind of overcome this case. Nike, as we all know, has the ownership of all the trademarks, and StockX is a resale platform, and they utilize the Nike trademarks to kind of advertise some authentication system that they had in place, where they sold the NFTs tied to the shoes that they normally resell. So they started reselling Nike shoes tied to an NFT, but the prices were a lot more than they normally would be, as if you bought any Nike shoe in a resale platform. So that was an indicator of they were getting value not just from the shoe, but also from the NFT itself. So Nike obviously sued. They are very protective over their marks, and they are also entering the space. So they definitely took this upon as a clear infringement of the trademarks. And if I'll go to the next one. These are the causes of action. There was trademark infringement, false designation of origin, trademark dilution, the injury to business reputation, and then common law trademark infringement and unfair competition. So those were the initial causes of action by Nike. And they were seeking injunction and the delivery of the remaining NFTs just to destroy them, and disgorgement of profits, and then compensatory damages, attorney fees, punitive damages. That's what they were seeking. Now, StockX defenses are actually very interesting because they argued that the NFTs are not virtual sneakers, and that should be one of the defining factors of whether they were infringing. So because Nike doesn't sell virtual sneakers, and neither does StockX is not selling any virtual sneakers either. At the time, Nike didn't have any virtual sneakers in place yet. But StockX argued that this was just an authenticating NFT. So basically, it traced the authenticity of the Nike shoes rather than actual selling the shoes tied to the NFT or the NFT itself as value. So basically, the customers wanted to make sure the shoes were authentic, and this is the way they created the authenticity value was on the actual tie of the NFT to the actual shoes. They also argued nominative fair use, which we kind of were foreseeing as an argument, and it was foreshadowing of what was to come next. And that was that they needed to use the image in the product, but this has been debunked a lot of times by commentators saying that because the price of the Nike shoes were so much less than what the stockists were advertising the NFT with the shoes. They were getting value from the NFT itself, not just the shoes or the resale of the shoes. And then the more interesting argument to me was the first sale doctrine. And that is just permitting, because we don't really have a lot of cases that kind of tell us whether the digital goods are, we have some cases that dictate that digital, the first sale doctrine applies to digital sale goods, but not in terms of the NFTs. So the first sale doctrine is an argument that StockX is making that may be the best argument they have in their hands. However, and I'll go to the next slide because this is a preamble to what happened next, is that Nike amended the complaint recently, and they included causes of action for counterfeiting, false advertising, and they claimed that they actually, over a period of 2 months, they went on StockX and they were able to get counterfeits. So the NFT was not actually authenticating anything. It was actually just being sold as the NFT for value rather than just the authenticating factor. So kind of like you get a receipt when you buy the shoes. That was debunked by them by arguing the counterfeit. So they also added facts, and I think this was kind of slid into the complaint. It was partly the intention of going for the counterfeit and the false advertising, but also kind of to add that they were entering into the NFT market. So they have since actually issued some NFT sneakers that are tied to their recent purchase of a company called CloneX, that is an NFT company that has some digital avatars, and now they issue some digital clothing for those avatars, including some shoes. So this is the current state of the complaint. We have a Nike made a complaint for the counterfeit and false advertising, and then a few days later, after they amended this complaint, StockX was actually named in a new class action lawsuit that by consumers, arguing that they actually purchased shoes that were counterfeits. So this kind of aggravates the situation a little bit more for StockX, and it doesn't really help the arguments made in defense. So a lot of people have disregarded that they are actually facing this class lawsuit, but I think that it points us in the direction that maybe Nike is onto something with the counterfeit argument. Questions so far? No? Okay. And if anyone wants to read the chat and there's any questions there, please do let me know. I can't, for some reason, it won't let me see a chat. I'll go on to the next case. This one is also trademarks and includes some trade dress. And we all have heard of Hermes and Mason Rothschild. And this one, the creator is an artist who started working on Metaverkins, and they actually had a really successful sale of the Metaverkins. It was intended to be more of a controversial sale at first. It included the fetus of inside of one of the bags, and they received I think it was about 47,000. Yeah, I have that in my slide. About 47,000 in auction for this specific bag. And it was a one-to-one, so it was just one specific artwork that was sold through this auction. So soon after that, the same artist created a new series or a collection that was inspired by the same kind of argument of fur-free alternatives and going against the actual Hermes use of leather and whatnot and other fur uses. So this collection was intended as a second drop. So the first one was the one-to-one, and this one was a larger drop. And the actual artist just mentioned or keeps mentioning that it's intended as a political statement or as a commentary on the actual Hermes bags and the materials they use to create their luxury goods. So this is the actual Metaverkins, and the ones that were dropped by the artists are in the back, so they have some fur around them. I still think they're quite similar. If anyone sees a digital purse that looks the same, it kind of embodies the same trade dress. Not to say that that's the way the court will rule, but they look fairly similar. Also, the only difference being really just the fur in on top of the bags. So this one, they actually went into negotiations, but despite the negotiations, they actually did file a lawsuit against the artist Rothschild for both trade dress and for trademark infringement. And this is a very interesting case because the argument by Rothschild is that this is artistically relevant, and the Rogers test, which as we all kind of have heard before, which is the balance of First Amendment and artistically relevant uses, and that kind of balances out the infringement. That's the argument that Rothschild is making, and the commercial sale aspect was irrelevant, basically, is what he mentioned. So this argument is actually really interesting because he also filed a motion to dismiss, which is in my next slide. And he filed the motion to dismiss for against the trademark infringement claim. And he argued the Rogers test applied on the basis that the digital image of the Mercury's bag were art and therefore should be protected under the First Amendment. However, the court denied the motion to dismiss and actually concluded that the arguments that Hermes used, which was the Polaroid factor, should be applied, not the Rogers test. The court concluded that the Rogers test and the Polaroid test should be applied. And he said that a court of law should be deciding this based on the facts, not really on a motion to dismiss. But this is going to be a really interesting one. I think that the Rogers test may potentially be utilized here just as much as the Polaroid factors to decide whether there's a likelihood of confusion. And we can all see that the use of the Metaverkins and the Hermes bags and the marks may potentially bring us to favorable decision on Hermes. But again, the art, whether that's First Amendment protected and whether it's sufficient, that's soon to be decided by the court. Moving
Eliana,
on. Yeah.
The fact that these are electronic images, does that really make any difference to the analysis? Would it be the same if they were paintings on canvas like Andy Warhol soup cans or just drawings on pieces of paper?
So I'm assuming you read the decision by the motion to dismiss decision by the court, because the denial of the motion to dismiss mentioned that this would potentially be different if they had been digital goods, so digital purses, as opposed to just the actual digital images of it. So basically, if you had a digital, what we call wearables, so if you could bring this to life into one of the avatars or the Decentraland or any of the actual metaverse lands that we have, potential that's what we read into the motion to dismiss, the denial of the motion to dismiss, that the court would have seen this differently if it would have been a wearable, so a digital good, as opposed to just the image itself. I disagree. I don't know that, I personally don't know that this would have been any different if Hermes had digital goods or if Rothschild had created digital wearables. And I think that individuals who see the images may likely still be confused as to the source, regardless of whether these are digital wearables or just digital images of the actual goods, if that makes any kind of sense. And it could be confusing because we still don't have a defining line of what becomes a digital wearable that you could wear in the metaverse, as opposed to just the image itself, because a lot of the NFTs are being given the utility that you could transfer these NFTs into a specific land, and they are operable in that specific land. So you could actually convert them into wearables in those metaverses. So that's where I disagree with the court, because I think a lot of the utility for some of the NFTs may be that they could be turned into wearables in the metaverse. So not sure that it changes the use of the Rogers Polaroid test, and I still think that it needs to be evaluated on the facts of whether there could be a likelihood of confusion and whether the art is sufficient to kind of avoid the infringement, if this is really just an art statement and not just a commercial use of the images by the artist to commercialize and monetize. Does that answer? Yeah, I know
Yes.
it could be confusing because we don't have a clear answer on the NFT versus digital wearable. But to me, it just seemed a little bit interesting that they mentioned that it could have been different had it been a wearable. Someone raised their hand, so please feel free to jump in and
Yes.
ask.
Susan, you have a question, please?
Oh, hi, yes, thanks. So are you saying that it could potentially be turned into a wearable in the future, and that's why you're saying that this should still apply?
No, so the court, not in the future. So right now, yeah, the facts of the case is that it's not a digital wearable, but I think that because this is setting precedent, a lot of the NFTs that are in existence do have the utility that you could utilize them, or they are operable in specific metaverses. So go ahead, sorry.
Oh, I was just acknowledging.
Oh, yeah, sorry. Yeah, so I don't think that, even though the facts of the case did not include the digital wearables, I think that, and it was a footnote that they put in the actual denial of the motion to dismiss. It wasn't actually in the body of it, which was interesting. I think I would have left it out if, because I think it creates an argument to be made that, okay, if I make a digital wearable, as opposed to just the image of the goods, then I'm fine, because this company doesn't make digital wearables, or I'm just gonna be making digital wearables, and it's different than just using the actual image itself for a creation or a work of art. However, I do see how a digital wearable may be more commercial in nature, and that you could utilize, it has utility. So you could wear it on the metaverse, as opposed to just a piece of art where you're just going to be admiring it for the art value. So I see the argument. I think this as a precedent doesn't really help the NFT space much. Just because there is interoperability of the NFTs in certain instances where you do have an NFT that could be taken to a specific metaverse and be used as a wearable, if that makes sense.
Okay, thank you. Could you please define digital wearable and metaverse? David Baca is asking that.
Yeah, so the metaverse we have is just virtual lands, basically, where you can have the avatars come to life. That's the easiest way to understand this. So we have, for example, Roblox, which already has had a lot of time in the space, just creating these avatars in kind of virtual life. We have Decentraland, we have Voxel. So a lot of different lands are not interoperable, meaning that they are kind of like different countries, and you can't really go to one without being able to operate in the other one. And right now, that's the way it is. There's no bridge to kind of utilize certain items on each. So when it comes to digital wearables, for example, Decentraland, you have to go directly through the specific land or that specific virtual world to create specific wearables. And a wearable is just an item of clothing, and it could be an accessory too. So glasses, bags, anything, shirts, pants that you create that could be used by your avatar.
Okay.
And those you wear them in that specific metaverse.
Okay, that makes sense to me. He was also asking if an NFT is more reliable legally than a copyright or trademark.
Reliable in which, so they are separate. So an NFT is just like the deed to what you own, whether that's artwork or a trademark. So I think they're separable, but could be united. So I did a presentation the other day about the potential of using NFTs to trace assignments or registrations. So you could tie them, but I wouldn't make them as more reliable. I think that they just make it a smoother transition or traceability to see who owns what and at what specific time. And because anyone can access the blockchain, it could be, it's transparent to anyone. I hope that answers the question. I'm not sure if I'm understanding that correctly.
I think that covers it. Thank you.
Okay. So these are the two main cases. So StockX and the Metaverkins are two that we're really waiting on to see how we treat NFTs and trademarks in the metaverse, especially. So we move on, and there's a right of publicity case. Actually, there's been about two. This is one of the main ones. And this is just a very common writer publicity case. And because it's so nuanced per state, this one was, I believe, in California. And this was an artist, a rapper, who sued a platform for using his name and image without permission to be used in the launching of an NFT project by the actual platform itself. So they just issued his image along with the materials that used to kind of the offering of the NFT itself, as kind of having him endorse it. And he sued for under the right publicity, under his name and likeness being used without permission. This one's pretty straightforward. Then we have some smaller, not too controversial cases. This is a cross-claim by two founders. And this goes into the next case that I'll mention in a second, but the Bored Ape Yacht Club, as we all know, is the most popular project here that we have and have come to know as the kind of the NFT poster child. They grant commercial rights to the holders, so they can create derivative works, they can create, they can commercialize the art that the NFT is connected to. So in this case, there were three founders, and they each had a Bored Ape, and they decided to come together and create a derivative work of art and launch it as an NFT, utilizing the underlying ownership of the Bored Apes that they held. So because they use different layers from these three different Bored Apes, they combined the layers of all three and created an iteration of, I think it was about 10,000 different ones that look kind of like this. They called them caked apes. This one, it's kind of messy because they are arguing, they're gonna have to argue which layers were used to use which Bored Apes, in this case, the derivatives. And this is just this one to me is very messy because we don't know at what point the license ended, because it was three different owners that had ownership over the commercial rights of a underlying asset that then got converted into a new one. So they keep taking down or misusing the DMCA. So that's another part of the arguments, that the DMCA is being misused, and they keep trying to get this project to be taken down from the platforms that are currently being sold on. And then at this point, I think they are in conversations to take this offline, basically, and just get it dismissed, or settle it before it goes to an actual court of law. But this one is just messy because of the next case, because the license that the Bored Ape has is not very clear as to what exactly they're receiving. So there's some arguments that are made that they grant full commercial rights, so sort of like an assignment. And then there's other arguments that exclusively say that it's a non-exclusive license, and this has not been addressed yet and has not been brought to court yet or in any lawsuits. So this is interesting because of the next case, and this is the most recent case that happened about 3 days ago. So I literally just made this slide about a day ago. This has been super controversial, and it's very exciting because we haven't seen this come to the forefront of all the news yet. So this case is about Yuga Labs, who are the founders of Bored Ape, and they sued an artist who was creating some commentary about the Bored Apes, and he actually mentioned a lot of comments that may not be true, again, dispositive at this point, but he mentioned that they were Nazis and they were racist, and kind of just really bringing down the image of the founders of the Bored Ape Yacht Club. And he decided to create a project using the actual exact replica of the images of the Bored Ape, and under a website that would actually create this Bored Apes under a different token. So basically utilizing the same image, creating a different NFT token, and then tying it to it, so exact replicas. He took it upon himself to voice this very loudly on Twitter and other social media outlets, which Bored Ape finally got tired of, and they went after him. So this just happened, And they actually went after him for trademark infringement. The bulk of the argument is surrounding trademark use, advertising unfair competition, and some common law claims for trademark infringement. But there was no mention of the copyright issue, or there were no defamation claims either, which was interesting. The copyright claim was really interesting not to be brought in under this lawsuit, but the argument or the presumption by most practitioners in this field right now is that they didn't want to open that can of worms because of how unclear their license is. So this ties back to the last one that we just heard about, which the caked apes is, which does not help us in defining how a license is going to be treated in this space, in light of how vague it is for them. So if you read their terms of use, it mentions you get full ownership, full rights of the copyright or the art that is tied to the NFT. But the following paragraph says that you have a non-exclusive, in other words, a non-exclusive license or royalty-free license. So the presumption is you get a non-exclusive license under unclear, if it's unclear in the language of terms of use, normally in the copyright language or grant. But in this case, it may be an assignment, unless if you could argue that the signature or the actual writing once you transfer the NFT is sufficient for an assignment, which is required, one of the signatures by the assignor. So again, this one didn't open that can of worms. It's just surrounding the trademark infringement, and we are still left with a lot of questions about the copyright license of the Bored Apes and how much does it really grant the owners of this NFT. So that one is my last case, and this is going to be the most interesting one, I would say, just because of how popular Bored Apes are. And the only thing I'll say about this one is the major argument that the artist is making right now in defense is that it was a parody. However, he made a lot of money from this copycat issue NFT, so I don't know how successful that parody would be as a defense. So now,
Eliana,
questions. Yeah.
Yes, let me ask, just to make sure that everybody understands the dimensions of what we're discussing today. Can you give some estimate as to how much commerce and how much money is involved with the Bored Ape Yacht Club and the related projects?
At this point, billions. Every time there's a transaction, they get about 2.5, I believe, from just the sale and the transfer of the NFT. So they have made a lot of money. There's a lot of money involved in this project. I could get an estimate for you, but I don't have it in front of me, but I could definitely find it for you. But it's just a lot of money that goes into this project in particular.
So where do you think the law will go with respect to these various topics that are so controversial and hotly contested right now?
So at this point, it's just very unclear. If we noticed, the majority of the claims that we've seen in the space surround trademarks, and I think we're kind of tippy-toeing on the copyright claims because we're just not certain how they will be treated. So I think we're starting with just the trademark use, and I think once a court defines whether there's enough in the trademark registration for example, like the actual bags, that translates into the metaverse, and whether that's enough to protect that specific brand. I think that would dictate a lot more than we have at hand. A lot of and I say that because a lot of the different companies, so like domains, GoDaddy and the domain companies have been issuing statements to their current registrants, encouraging that their current registrants have that they register for the metaverse kind of classes, or that they register the domains under the Ethereum networks and the other different networks that we have. So like crypto. So a lot of the Ethereum networks that and then that ETH or that crypto or that Bitcoin, they have been encouraging the marks or the companies to register under those. So that kind of dictates a little bit of where companies are seeing this, and I think the court may follow suit. I don't know that if you have a registration for a specific mark that it's going to be so, it's going to also kind of protect you under uses of the same mark in the metaverse until the court decides that. So, and then as far as the copyright, I think we need a clear answer as to how would licenses be given notice to the holders in particular. I think that's one major issue that we're seeing, because we don't have anything to give subsequent buyers of the NFT notice as to what license they're receiving, unless that specific person goes to the terms of use. And that's an active, so they will have to actively go to the terms of use of the NFT they're purchasing to decide or to determine what they are getting. Sorry for the noise. Apparently someone's building upstairs.
So how much of this, Eliana, in your opinion, calls for legislative action? And to what extent do our current laws, the Lanham Act, the copyright statute, to what extent are the current laws adequate to deal with the challenges that these new forms of commerce are presenting?
So I think that we have very outdated laws applied to new technology, but I don't think they are that, not that they're far off, but I think that we can still use the same laws. I do think so. I just think that we need precedent to see how they are applied. So in regards to IP laws, so the Lanham Act and the anything that's just related to the IP uses in NFTs, I think that we could still apply the same laws. I just think we need to know how a court would read those to be, how would they would apply those to the current technology. I have more issues at hand with regulations involving securities and involving the legal formation of a lot of these projects. So a lot of these projects are providing potential dividends or royalties to its holders. I think that the laws that dictate whether something is a security, those are definitely outdated. They're still from the 70s. So I take up more issue with those regulations rather than the Lanham Act and all the IP laws that we have at hand. I have more issues with those, certainly. And then the formation of the entities. So a lot of these projects that we normally see are founded by DAOs or decentralized autonomous organizations. And the DAOs right now are not recognized. They're considered general partnership. Depending on the state, they will be considered a general partnership or a joint venture. But there are some states that are recognizing DAOs as LLCs. So Wyoming, Vermont, and I forget the other one. There's about 3 that have a Wyoming DAO statute and or the like. But I have more issues with those sort of structures. So anything securities, anything business formation, I think are more outdated than the current Lanham Act.
Can you give us a little orientation as to what DAOs are, who uses them, and for what purposes they are used? And I know that's new territory to many of our viewers.
Of course. So a DAO is a decentralized autonomous organization. And the intention of the DAO is to have code be law. So these are organizations that are not ran by one individual, but by multiple individuals, and they dictate the way the organization goes through code. So an algorithm that they all agree on. So for example, the DAO that Wyoming allows creation and recognition as a DAO LLC has, in the form, when you form it, they don't ask you, it's optional, but they don't ask you for the names of who's going to be the members or general partners or founders. They ask for an algorithm. So which is the contract where it's going to be ruling or making the decisions for this DAO. So they use different houses is what I would call them, where you have different algorithms and all the members get to vote in those algorithms. and it's just ruled by code basically. So these are organizations that are decentralized. So there's not one major form of authority or not one president, not one CEO. It's everyone is on the same level. Everyone's making decisions equally. And the benefit of that is you have people from different countries, you have people from different areas, and they all collaborate for one common enterprise without having to adhere to one central authority. So these are very common in the NFT space because people want to have ownership, and I think Web3 is about owning what you create and kind of having a democratizing a lot of the ownership. So decentralized autonomous organizations are very common and popular in the NFT space for that reason.
Can you give an example, Eliana, of a DAO? Why would somebody form one? Why would somebody join one?
Yeah, so we have different DAOs. Some of the most successful ones. One, it's called Flamingo DAO. This one is they actually go through the KYC process, and so they know your customer process, and they go through securities laws. So they have an actual need for accredited investors. So they require that. So they have a filing with the SEC. But for example, they formed as a DAO so that all members could have equal say in what they invest in. So these are investors in NFTs, and they will purchase NFTs, sell NFTs, and trade NFTs, but everyone has an equal vote as to what they do and how they do it. So the DAO is essentially, they have a very large number of members, and there's no central authority to dictate what they invest in, how they invested in. It's just basically voting through the algorithm, and then they change the algorithm based on the votes of the members. And that's how it's run. It's decentralized. There's not one president, not treasurer. Everyone kind of chips in. And then there's other DAOs that are more nonprofit in nature, where you have, for example, the DAO that was created for sending funds to the Ukraine during the war. So they formed the DAO, and anyone can participate. Anyone can give what they can, not just financially, but in labor too. So a lot of people are employed by DAOs, or not employed by DAOs, but they work for a DAO, and they just chip in with their skills, and they just have this organization that has no central authority. And if they raise the goals, they have the goals that they meet, and they kind of achieve them by just having a decentralized authority and everyone having equal say.
And so are these securities? It sounds like under the Howey test, there's an argument there that people are pooling resources, hoping to profit from the activities of others, those sorts of tests. What do you think?
That's my main concern with a lot of these projects and with the DAOs. Some DAOs are doing it properly, like Flamingo DAO, for example, like I mentioned, they actually have a filing. They use an exemption to the securities laws under 506C, I believe is the one they use. So they have these exceptions filed with SEC. A lot of the DAOs are utilizing this now, since they've seen a lot of the issues coming at hand. Some of them are going under the radar. I do agree with you. I think there's no real clear line as to when someone is deriving a profit from the efforts of others. I think that in DAOs, it's harder to prove just because you have a decentralized authority and everyone is kind of chipping in, as opposed to having one person being the sole worker and everybody else profiting, which is normally how you would say that the securities will fall under that scenario. But there have been some arguments as to Ethereum itself, from the moment of its inception, that it transformed into a non-security because of the decentralized manner in which it works, which is multiple nodes of multiple people in different countries, different spaces, and it's decentralized. There's no one center that kind of controls whether the value of it. So it's just, I take up more issue with those regulations right now. There's no clear line as to when something is going to be considered a security. However, I would normally advise that anything or any project or any kind of NFT founder that issues something with the expectation or creating an expectation of profit for the holders that may be crossing that line.
So for those of us who are in the conflict resolution business, what do you think are going to be the most common disputes arising, the kinds of disputes to which we will be devoting our attention in the months and years to come?
Interestingly enough, I've heard of a few not projects, but guilds under specific DAO. So there's a legal DAO called Lex DAO, and they have sub DAOs. Basically, they have sub working groups, is the best way to kind of understand it. And these working groups have actually been working on potential ways of creating dispute resolution systems, utilizing the metaverse, interestingly enough. So they will have a land or a parcel of land in voxels or any other metaverse, and they will have the actual dispute resolution happen there. So they're creating systems where you utilize Web3 for dispute resolution and arbitration potentially. And that's just one of other groups that are trying to kind of create alternatives to these lawsuits that are coming at hand. But I certainly think that Web3 can come in handy for anyone in the dispute resolution space, because we don't want to see a lot of this go to court, but at the same time, we don't have a lot of the systems that are Web3 friendly. So I do see there's a space and a need for that.
And if people want to learn more or hang out where the top lawyers and business executives are hanging out, where might we look to go or to get more information?
Yes, so right now, and this may seem a little bit crazy, but Discord, if you're not familiar with Discord, the system for messaging, a lot of these companies are using this, and a lot of the DAOs and the working groups are utilizing Discord to message each other, to have the working groups work there. So there's two in particular that I would recommend. The first one, and I could share the links to the Twitter spaces that they have and to their Discord. And if you're not familiar with Discord, I would start in Twitter, but one of them is Lex DAO. I am a member of Lex DAO. They have really good and really smart people. There are also a lot of legal engineers. So they have the people who can read code in the smart contracts as well. So a lot of us are trying to kind of get well-versed in how to read the smart contracts for the legalities, not just the actual code and the algorithm itself and the yielding functionality, which is important, I think, in this space. So that's Lex DAO. And then we have blockchain barristers, and blockchain barristers is not as technical, it's not as legal engineering as it would be. And it's just a club per se of attorneys working at Web3. So if you want to get familiar with other attorneys, this is just mainly for attorneys. And we have some law students, but the majority are just attorneys trying to either enter the space or already really familiar with the space and have questions and they want to collaborate. It's very collaborative, and it's a space because it's so small still that people are kind of still helping each other try to figure out answers, because we just don't have a lot of guidance right now. So those two are the main places I would go to get well-versed in the space and what other projects are coming up with good alternatives to dispute resolution and arbitration.
And what's the best way to get in touch with you if people have questions or want to follow up with you?
Yeah, of course, email or Twitter. I respond to either one, or LinkedIn. So I respond to LinkedIn, Twitter, or email, whichever way. And I could connect you with any of these working groups. So whether that's Lex DAO or blockchain barristers. So I would be happy to make that connection.
Fantastic. What's your email, Eliana?
And let me see if I could put it, let me stop sharing and put it in the chat. And just any questions? I know this is a very interesting space, but also very complex. So if there's any other questions, please do feel free to reach out to me. I will be happy to make any connections with anyone else working in this space as well, if you have any other immediate questions that are more particular to a specific area.
This was fantastic. We could go on for a long time. Our time is up. Eliana Torres, thank you so much. Your email is elianatorres.law@gmail.com. Thank you so much. We hope that people who are in a position to contribute to the Alive Food Bank in Alexandria, Virginia, do so. That's the Alive, ALIVE, Food Bank in Alexandria, Virginia. We'll be back next week with another great program. Eliana Torres, on behalf of Jean, Sarah, Natalie, and myself, thank you so much. And with that, we are complete.
Thank you.
Thank you.
Thank you, fantastic. We need to stop the